If you have been served with a restraining order, you're probably in the process of starting to gather any evidence that you may have, whether you are the petitioner or the respondent, to show the judge. But there are certain types of evidence that are actually not supposed to be brought in front of the judge. And it is important to know this in advance so that you can stop the other side from using it. But it's also very important that you do not rely on using this type of evidence in court. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish exactly how to represent yourself at your restraining order hearing and win. So if that is something that you are interested in, you can find your free first class via the link down below. Okay, so let's jump right in. I'm going to go through 3 types of evidence that people commonly try to use in restraining order court that the judge is not supposed to review. And this is important because if the other side tries to use them, then you can object. But you also you don't want to expect that you're going to be able to use them and then have the judge shut you down. Number 1, your own statements. So let's say you have text messages from yourself, or you want to testify to the judge about things that you said to other people, things that you said to the other party. You are very likely not going to be able to use those statements because they are considered hearsay. Hearsay is something that someone said outside of court that in court you're basically trying to quote. Now, there are exceptions to it. One exception is going to be bringing in the other side's statement. So you can say things that the other side is trying to say. But typically, and again, there are some exceptions, things that you said, you cannot give to the judge as evidence. So you don't want to rely on emails that you sent the other party, text messages that you sent to the other party as evidence in front of the judge. Now, forgetting about the legal and complicated part of this, if you think about it, a statement that you made is not necessarily persuasive, right? You can write anything you want in an email. You can write anything you want in a text message to the other side. You can say, hey, I'm really upset about how you hit me earlier today. That wasn't nice of you. And so it's not good evidence. It's not reliable. And that's one of the reasons for this rule. So you want to get better evidence. And better evidence, maybe you don't have anything that is hard, irrefutable physical evidence or proof or a witness. Better evidence is just your testimony in court explaining to the judge what happened. Number 2, police reports. So I actually got a comment recently from someone on YouTube about how they were trying to use police reports in their restraining order hearing, and they were surprised that they weren't able to do it. Typically, they are hearsay in restraining order hearings because what a police report actually is a police officer writing a statement, not just what they observe, but what people tell them. And so, of course, it's not reliable. In fact, I do not just restraining order hearings, but I do criminal defense, and I get the police report first. And later on, I get the body-worn video. So I see word for word, what did the witness or the victim or my client actually say to the police? And often it differs significantly from what's in the police report. I mean, if you imagine the police officer's night, they go to one house call, they go to the next, they're maybe making some notes, but they have to write up all these reports here. It's not going to be word for word. They're going to summarize. They're going to get some details wrong. And so it makes sense that using a police report against someone else wouldn't really work. In criminal cases, it doesn't really work either against the alleged victim. If the police officer says that they said something to the police officer in the report and then they say something different on the stand, if I were to try to confront them with the police report, I can't do, but let's say I tried to do it, their explanation is going to be, well, I didn't write the police report. That's not what I said to the officer. I don't know why they got it wrong, right? And so police reports are not admissible in restraining order hearings typically. Number 3, medical records to prove what is in them. And there are some exceptions to this, but a lot of times petitioners will try to show medical records that have a statement from a doctor or have a diagnosis. The problem with this, again, is that if the doctor is not there, if whoever wrote it is not there, then we can't ask them questions about it. We cannot poke holes in it. We cannot even rely on it. Maybe they got something wrong. We can't even have them authenticate it and say, yeah, I wrote this down and here's why. And so that also is something that is not admissible. Now, look, if you want to try to admit one of these things, your own statements, police reports, medical records, you can try in court. I'm warning you that they are not supposed to be admissible. And so you wouldn't want to think, oh, well, I have a really strong case. I've got the police reports. I have the medical records. It's all good here, because that's not true if that's all that you have. I won't even bring my witnesses, right? You wouldn't want to rely on bringing it in. But you can try. Some judges, unless the other side objects, they're going to let hearsay in. They don't really care. Other judges will say, you know what, I can't look at that police report because it's hearsay. I can't look at the medical records. It's hearsay. Now, if you are on the other side, and in this video is a very brief overview of this. I go into it much more detail in the course that I teach on this. If the judge seems to be willing to accept this and look at it, what you can say is, objection, Your Honor, this is hearsay. In general, you should not interrupt the other party while they are speaking. You should not interrupt the judge while they are speaking during a hearing. But the one exception is for an objection. And this is what lawyers do too. You see it on TV, right? And I'm not saying do it gratuitously like you would do on TV, but if one of these things is coming in, the other side is giving a long speech on something that they said, or they're trying to show the judge a police report or a medical record, then say objection, hearsay. And the judge actually may be relieved that now there is an objection, and they may just sustain it. Now they don't have to listen to any of that, but maybe they have a policy of they're going to just treat all the litigants as though they did have attorneys, and if you don't object, that's your problem. And secondly, they may be a bit shocked at first that you objected, because most people in court don't know how to object, right? And so just everything comes in then unless the judge says it can't. But if they realize that you actually know what you're talking about, not only could you potentially keep evidence out, but you'll also gain some credibility with the judge, because you know a lot more than 99% of people, probably even higher than that, who are representing themselves in court. And so you have shown the judge that you are a smart person and probably impressed them a little bit. For these restraining order hearings, it is all about credibility. The judge only has to find for one side slightly more than 50%. So if they feel like you are a credible person, a smart person, diligent person, and getting an objection sustained is one way to get them to agree with that, then that is going to definitely cut in your favor. I hope you found this video helpful. If you do have a restraining order case and you're planning to represent yourself, then get your free class in the course. I mean, whenever you're trying to learn something new, the biggest problem is that you don't know what you don't know, right? And so in the course, I teach you, okay, here's everything you need to know. And then I explain each thing that you need to know so you have it all ready for you, basically on a silver platter. And if you have a restraining order hearing, you're looking for an attorney, you can also find a link to book a call with me for that down below. And if you did find this video helpful, please don't forget to like, subscribe, and ring the bell, and follow me on Instagram, TikTok, and Facebook.